And we've chosen today's topic, and you may have seen in the past, it's an area that we focused on, to look particularly at cyber risk. And in the webinar today, we've put together people from our team and experts in their field to try and uncover and unmask cyber risk in a practical, meaningful way so that everybody can take something home and understand what is required in the process to cyber readiness. We begin this process by talking about cyber readiness because none of you or any of our clients will ever be cyber secure. We don't know what attacks look like tomorrow, but what we do know is that the more prepared we are, the better our chances are recovering from those attacks if they do hit our business, and the safer we are in our general daily activities in engaging with clients and the business of our business. And what we have found incredibly important is to understand your risk environment, your information security environment as best as you can. As we'll see later, we'll talk about Black Swan events and how people who are as prepared as they could possibly be have fallen victim to cybercrime. But the point about that is that those people who are prepared have a better chance of recovery, maintaining their business, and making sure that they don't have catastrophic events interrupt their business process. So the talkers today have knowledge in all these different areas of risk management and are going to share this information with you. We're going to kick off today with Michael Lash. Michael Lash is an expert in GRC and has been involved in South Africa with most of the largest and listed public companies in helping them navigate this incredibly difficult area of business practice, with a specific slant towards an increasing expertise and growing interest in cyber risk and how it affects the board of directors and who's responsible ultimately for the information security in a business. So Michael, if we can turn to you and you can begin, I'd appreciate it, and we can take this forward. Thank you very much, everybody. I hope you enjoyed today's session.
Excellent. Thanks, David. Would you like me to keep my video on? We didn't confirm whether the full bandwidth.
Yes, yeah. If you can keep your video on, Mark, but share your screen as well. Thank you.
Okay, will do. Thanks, David. So, good morning, everyone. It's good to be here. I'm specifically tackling the area of. You can't see my screen yet. Sorry, apologies. There we go. Is it visible? David, can you confirm?
Yes, we find Mark, you're on.
Excellent. Marvelous. So I'm going to be tackling the area of ICT and cyber risk as a component of corporate governance. Maybe just to start, an introduction about myself. So I'm born and bred in Johannesburg. I'm a family man. I have 4 daughters, the eldest of which is a qualified physio, already practicing at Netcare Hospital. And then my youngest is 3 years old. So that means that I will be working for the next 25 years. In terms of qualification, I did a Bachelor of Accountancy at Wits. I went straight from school. I went into a part-time environment and did education. I ultimately wrote the Chartered Accountant South Africa board exam successfully in 1992, and then joined a multinational company as the CFO and stayed with them for a while. It was a company in the chemical industry that serviced the metallurgical industry. And from there, I then got the opportunity to serve as CFO of one of Johannesburg's listed financial services companies. And thereafter, I started my own business, which was in collaboration with the Institute of Directors, and we conceptualized the discipline, or taking the governance code and turning it into a digital management framework. And I'm still involved with that. We boast that we have more than 1 in 3 listed companies using our products to have oversight, manage, monitor, and report on their corporate governance. So over the last, and that I've been doing for 12 years. So I have gleaned some insight into the governance environment. So the big idea that I wish to speak about today, and just give you some insight over, hopefully you walk away with this as the big idea, that as a well-governed company, you have a greater probability for success and long-term sustainability. That's been proven by multiple studies that have been done, that companies that are well-governed are more profitable and sustainable over a longer period. And together with that, that ICT and cyber risk management will be the most important aspect of good corporate, excuse me, good corporate governance. So maybe as a start, the term corporate governance, for many it conjures up grudge by and complexity and compliance and legalism. And maybe it's worth just clarifying that it actually is not a term that should conjure up any reservations or hesitation, but that it actually is common sense and just good practice. It is actually a descriptor of the manner by which the actions and affairs of an organization are directed and controlled. So good governance means that the directors, the leaders, the managers of an organization are directing and controlling all the actions and affairs of the organization with a level of competence. And so maybe just looking at the basics that make up for good governance, the very most obvious one is competence of the leaders and managers. So if you want any chance of being well governed, make sure that you've got a competent leadership team. Competence is the descriptor that describes very much the ethics of the leadership team, the skills of the team, the experience that they bring to the arrangement, and also the industry knowledge. Specifically, the individual leader and manager has certain duties, fiduciary duties. The first one deals with good faith. Good faith is very much that there's no conflict of interest. So the leader manager should always be looking out for the best interest of the organization without compromising it with a hidden agenda for self. So that's the concept of good faith. Care is the descriptor that the leader should be stewarding the assets of the organization as if it were their own. Skill is the one of bringing the training and experience to the organization, and hopefully the person is sufficiently skilled to be fulfilling their function properly. And diligence speaks to the commitment and the time and that the director, the leader, applies to the organization. So that's the concept of competence. Then just in terms of the next one is composition. So an important governance aspect is to have the right composition of competent leaders and managers. And composition is important that you cover all aspects of the functions that need to be fulfilled. A good exercise is to review that all the functions that are required are well catered for by the leadership team. The next responsibility of leaders and managers is that they are thinking strategically, and that it's a long-term and not only short-term, but that it's a long-term and medium-term thinking. A consideration by the leaders and managers must be to consider all the risks in the organization and those that might be arising, and that if the risks do arise and materialize, that there's sufficient mitigation against that risk. Then any good leadership and management team will be thinking about digitizing and doing technological improvements.
Can
everyone please just mute their mics? Thanks, guys. Okay.
So leaders, managers in today's environment must be thinking about digitization and technological advancement to be sustainable. If one isn't doing digitization of internal controls and even of one's own product, one is very likely to be non-competitive in the market in the short term to medium term. Then a big function of good governance, of course, is that there's always adequate internal controls. One wishes to make sure that the company isn't being fleeced or that there's no misappropriation of assets. Then, of course, compliance with all the laws and regulations. So these are the concepts that the leaders and managers need to be implementing in an organization for good governance. The last one is that the leaders, managers seek optimal relationships with all stakeholders. So it's not only about servicing the shareholder. Clearly, one needs to be looking after customers. Good relationships with customers generally develops good turnover and good profitability. But it's also important to have good relationships with the other stakeholders, one's staff, one's suppliers, the receiver of revenue, even the community, and environment would be covered by the stakeholder relationship. And then lastly, good governance dictates that one is transparent as an organization, and that normally is reflected in good reporting to stakeholders. So those really are the basics of governance. The big ticket items that I'm going to be just touching on, and what this conference really was about, is risk management. So risk management is a component. David, I'm just...
Yeah. Sorry guys, can everyone just mute themselves, please?
David, I actually think that you are able to mute people from your side as administrator. I think you can give a global mute. I'm not sure. Yeah, okay, so there we go. I was muted too. I'm back. So the big ticket items that I want to touch on is risk management, and risk management is specifically. Oops, sorry. So here, this is just addressing the importance of risk. So working together with the Institute of Directors in South Africa, they identified that risk management by a board is the most important function that they fulfill. This is a dashboard diagram of the product that we had developed with the Institute of Directors. You can see there are the various components that make up for good governance, and there was a rating mechanism. But here you've got a weighting graphic that reflects, sorry, did I accidentally moved ahead, sorry. Here's a graphic that reflects the extent to which risk was weighted in context with the other precepts of good governance. And you can see how much emphasis the Institute of Directors put on risk management. So clearly there is definitely a leaning or a propulsion towards the directors doing risk management as a important discipline. The next item is digitization and technology. So here, undoubtedly, every company needs to be doing implementing digitization in terms of their internal controls and their thinking, and there needs to be technological advancement in product development. But with that comes a new risk, namely the ICT and cyber risk. This is a quote from John Chambers at a conference in 2018. There are two types of companies, those who have been hacked and those who don't yet know they have been hacked. Of course, I think he was just making the statement or trying to highlight the importance or how critical cyber risk is. I don't think it is as serious as that. But cyber risk definitely is needs to be at the forefront of all thinking. Just to give you an idea, in 2017, June 2017, the biggest cyber attack in the history of the world economy happened. It was called NotPetya. It was a malicious attack that was orchestrated by the Russian government against the Ukrainians. Well, it's believed that to have been the case. And in that attack, it spilled over into the offices of Maersk, a big shipping company. And Maersk went down within 1 hour. Their total network was obliterated, crippled, and Maersk had representation across 130 countries in 574 offices, and they all went offline within that hour. They stayed offline for 9 days, and in that time, Maersk incurred a total loss of approximately $300 million, and they were lucky in that there was one office in Africa that was not compromised. And the reason for them not having been compromised is that the country was had a power outage in that hour, and the Active Directory system was saved, and they were able to harvest all the intelligence to restructure their system from that one server directory. That the total estimated loss globally across all the companies is estimated for that one incident to have amounted to $2 million. Pretty significant. It was in 2017. We haven't had an attack of one single attack of that magnitude, but the extent of attacks is increasing from year to year, but by multiple instances of attacks rather than individual significant attacks like this. So that's just the risk related to technology and digitization. And then there's risk related to compliance. So you might all be aware that that Europe has the Gdpr legislation that fines you for data compromise, and in South Africa that act has also been implemented. It's called POPI, and so it's not only a matter of now losing data or having a compromised data by a hacker. One also now has the risk that one incurs financial losses by virtue of a fine. This was the biggest fine that's been recorded to date. It's British Airways. They had a breach, a compromise of their clients, of 500,000 of their clients had their data compromised through the BA system, booking system. And even though British Airways guaranteed the reimbursement of any losses incurred by any of those 500,000, and they had very good security controls in place, they were fined £183 million. That £183 million actually was a fine that was lenient because it was only 1.5% of turnover, and the Gdpr fine for data loss is actually set at 4% of turnover. So by virtue of British Airways being able to evidence that they had taken sufficient measures to protect against data compromise, they got a lesser fine. So how does one do good governance? And so here the idea that was promulgated by the Institute of Directors in South Africa was very much that it is a case of maintaining registers to have oversight, manage and monitor and report the degree and extent to which governance practices are implemented. So it's really digital secure data repositories that facilitate for good governance as an evidence, a measure of evidence. And so a good register is basically a digitized system with all the built-in security and access control and data security that is process-driven. So it has a robust methodology. And by that process and robust methodology, you have the assurance for completeness of the exercise and oversight, as well as credibility of the content and the level of review. The register then acts as a mechanism for evidencing that the right things have been done and that all of it has been done, and that makes for good assurance to stakeholders that there's good governance. A register facilitates that there's transparency and that one can produce standardized reports from such a register. It empowers the custodian and the person that's responsible for the function to be able to evidence that they've done the exercise, as well as facilitating reporting to board of directors and stakeholders the application of good governance actions and practices. So just to give you an example, I mean, this was the governance register that was developed with the Institute of Directors on King 3. And as you can see, you've got the principles, and then and the principles drilled down. And under all of these principles are practices. And there was a rating mechanism that was developed by the IOD. Just in terms of King 4, the development has been further. This here, in fact, is one of our listed companies using the King 4 register. You can see this is very active. It's on their website, and you can actually, so HCI as a listed company, actually on their website, they publish their governance register by which you can interrogate every practice that they are applying and implementing to fulfill the principle of leading ethically and effectively. And you can see they've mapped it across to legislated requirements. So that's a governance register in action. When it comes to a risk register, again, it's a registry mechanism, and here you've got the various risks, and as you can then drill down and look at the details of the risk and how the organization has mitigated their risk from an inherent score of 64 down to 42, etc. And then you've got this ability for office bearers and stakeholders to see a risk register. When it comes to compliance, so this here is now a compliance register on ISO 27002. Again, you've got the categories of ISO, and within the categories, you would be able to drill down and see the evidence of how all these categories of ISO 27002 are fulfilled. So in conclusion, well-governed companies are successful and sustainable in the long term, and should be an aspiration for every business leader to get well-governed for that assurance of sustainability. It has been shown that every corporate failure can always be traced back to a governance breakdown. And so implementing a registry mechanism to just make sure that one is covering all good governance practices definitely mitigates against a corporate failure. Cyber risk and related security is undoubtedly the most important governance consideration in the next decade. And so I'd like you, hopefully you leave knowing and being motivated to pursue the principles of good governance, especially cyber risk management, and thereby that you will enjoy the fruit of a sustainable organization. So thank you, David. That's my presentation.
Thanks, Michael. Thanks very much. I think what we're going to do is leave a little bit of time at the end for any questions where we can answer them. But I think because we started a few minutes late, I'd like to get down into the rest of the agenda. So Lucien Pierce from PPM Attorneys is a regulatory and cyber crime specialist. Lucien is going to deal with 3 issues, and these issues have become more and more apparent with the client base we deal with and growing interest in Namibia around POPIA and Gdpr, which are obviously 2 sets of legislation that have an effect on businesses doing business in South Africa and obviously in Europe as well. And he'll be looking at why cybersecurity is so important, and also the consequences of cyber risk non-compliance. And what I think Lucien's going to throw at us here is a lot of case studies where you can see how companies have dealt with successfully and failed in their attempts to deal with these compliance issues. And then, of course, there is the Cyber Crimes Act in South Africa, which is an important piece of legislation which will force us all to be looking more closely at the consequences of cyber breach. So Lucien, if you are there and online, if you can just show your face and then take over.
Morning, David, and thanks for the introduction. Before I continue, I just want to make sure, David, that you can hear me well and you can see me clearly. I'm on the beautiful West Coast. In fact, I could have just hopped across the border and presented in person, but can you hear me loud and clear?
Yes, we can hear you. We can see you. You need to share your screen with us and we're good to go.
Okay, perfect. Will do. Good morning, everyone. It's great to be with you today. I'm an IT lawyer, but I'm just going to try and figure out how to share my screen, if you give me a second. Hopefully you will be able to see from beginning.
We can see you and you're ready to go. There we go.
Great, perfect. Okay, so thanks, Michael, for that introduction. I'm a little envious, I suppose. You've got a beautiful big family, 4 kids. I have 2. I try to convince my wife to have a few more, but she says I'm not wealthy enough to pay for the school fees. So yeah, you'll be working for a while. So just in terms of what we're going to deal with today, as David said, I'll be looking at South Africa's POPIA, as we call it. Some people call it POPIA and others call it POPI. But our information regulator has specified that we must call it POPIA. So we're going to look at it, just a very quick overview, because 30 minutes isn't sufficient to get really in-depth into what it's about. And I think part of the intention is to give you an idea of what a law like this is about, because from what I gather, Namibia is in the process of drafting its equivalent. I'm not sure when that's going to be ready. But in any event, if there are going to be disputes before you have a piece of legislation like this, I know that your laws have provisions. I'm not sure if it's the Constitution, but there are privacy protections in there, which you could then perhaps take examples from other jurisdictions should there ever be a dispute, or should you ever be defending some sort of action against you. What we're then going to also do is look at the Cybercrimes Act, and just give you a quick overview of that. It's a fairly new piece of legislation. It was promulgated in May of this year, and it's not even effective yet. But I'll tell you a bit more about that when we get into that. Just a quick intro about myself. I have been practicing for 24 years. I started out as a human rights lawyer practicing in Durban around the early 90s. I then packed up, gave up a potential associateship, and went backpacking. I so happened to arrive in the UK at one point. It was broken, was offered a job by a tech law firm called Bird & Bird. And having been somebody who actually wanted to be an engineer, it was a wonderful opportunity. I was thrown into IT law and started dealing with networking and frame relay and all those complex aspects that you IT people would probably know more about. And I was absolutely hooked. I came back and spent 4 years at a law firm in Joburg called Weber Wenzel until 2004. And since 2004, I've been practicing for my own accounts, focusing on IT law and of course, cyber-related issues. My firm is made up of 12 lawyers. You'll see that I don't feature in the picture because I work with some really excellent women lawyers who focus on ICT, and I've probably been shoved off to the side there. But yes, there are 12 of us who deal almost exclusively with ICT law. As far as Checkmark is concerned, we have a very good relationship, and we've been working together for a number of years, so we work well together. Privacy matters. Michael mentioned a couple of case studies and issues that many firms and organizations have experienced. He focused on Petya, which, as you would have seen, really had devastating consequences across the globe. You know, he mentioned Maersk, but there were quite a few other companies like Renault. A group of hospitals in the United States were badly hit to the extent where they were unable to proceed with important surgical procedures because some of the software that they used to record doctors' recommendations for the procedures was inaccessible because of that NotPetya attack. So more recently, we would have seen attacks, for example, on Nedbank. That attack actually wasn't directly on its systems, but on its operators, as we refer to it. And I'll explain the word a little more. But service providers were the source of the attack. Very similar to what happened to JP Morgan when it suffered a major breach, which again came through a third party. So I highlight that at this point, because often you might think that you've got the best systems, but the reality is that your service providers are the weak point. During July, we saw Transnet go down for almost a week because of a ransomware attack. Transnet immediately declared force majeure to try and defend itself from potential actions from all those who are wanting to use the port. And we'll briefly touch on whether that in itself is a sufficient defense. But why I highlight this is because, as you can see, Michael mentioned some of the fines that have been imposed, But if you look at the top corner there, you'll see Marriott Hotels, for example, was fined 18.4 million for a data breach. And in this instance, it happened once. It happened a second time. And on the third occasion, the Information Commissioner in the UK said, no, hang on, Marriott, look, you're clearly not learning your lesson, and imposed a fine, which had a punitive element to it. So yeah, in terms of what we deal with, there's going to be a brief overview of POPIA, as I said. I'm going to touch on a few case studies just to give you an idea of why privacy does matter. I'll give you some tips on handling data breaches. I've been through a few, some where we've come in and where we found that the client hasn't handled the matter in an optimal way to benefit from a legal and regulatory perspective. I'll then touch on GDPR and see how it affects Namibian businesses and whether it in fact applies to you, and then give you a brief overview of the South African Cyber Crimes Act. So POPIA, POPIA, depends where you are, but basically it's South Africa's Protection of Personal Information Act. What is it about and why do we have it? Well, just like many other laws, for example, the National Credit Regulator, the act that governs it, South Africa's National Consumer Act as well. In each instance, when it came out, there were a lot of people who said, you know, do we need another law? Do we need to really become such a nanny state and regulate ourselves to the point where lawyers are involved in everything? Well, the reality is if we don't have laws like this, then we're going to have a repetition of many of the problems that we've seen in the past. And you might ask, well, what are those problems? Well, we need laws like this because we've seen major life-threatening and actually life-taking events arising out of the misuse of personal information. If we go back to the 1940s, when the Second World War was in progress, how the Nazis managed to pursue the people that they really detested, you know, the Catholics, communists, Jewish people, was during the point that while invading and occupying small villages and municipalities, the first thing they would do is they would go and visit the mayor's office. And the reason for doing that was because the mayor often kept detailed records of all the constituents and all the voters in his or her area. And that record or those books would include the names, the number of people in the families, their religion, and a bit of their background. And so when the Nazis invaded, they would have an instant source of information as to who was a communist, who was, not my favorite term, homosexual as it was termed then, where the Jewish families were. And they would immediately be able to go and easily round up these people, and we know what followed after that. So after the war, it was Germany itself that decided that the use of personal information, especially sensitive personal information, should really be highly regulated. And it was the state of Hesse in the 1950s that passed a law, the first privacy law, in fact. And they managed to see the benefits of regulating this information, and then it spread across the rest of Germany, and after that across the rest of Europe. And they had their first major data protection law in 1996 called the Data Protection Directive. So we see protecting information, especially sensitive information, is important. Of course, in South Africa, we have a constitutional right to privacy. It's enshrined in the Constitution, and it also requires our government to pass two laws. One law that deals with the protection of personal information, and the other law that deals with access to information. We come from a past where people's privacy was invaded. We come from a past where ordinary citizens could not access information on what the state did. And for that reason, we have the Protection of Personal Information Act in South Africa, and we have the Promotion of Access to Information Act, which gives people the right to access information held by third parties. So as we see, we have these two very powerful pieces of legislation, both of which are regulated by a relatively powerful and influential regulator called the Information Regulator. Our law came into effect in July of this year, and we've seen since then, there was a lot of frenetic activity as everybody prepared and got themselves ready. Some still haven't. We're still assisting some pretty influential clients who are only now waking up to this, that they need to get ready. But the regulator has been quiet during July and August, and having been involved in this area for the past 10 years, I think that the regulator is going to kick off with a bang and make an example of one or two very important organizations. So that's the background to Papaya. I think some of the lingo or the language that you would need to know, particularly if you are doing business in South Africa or if you have affiliates in South Africa, you're going to need to know a bit about Papaya and its terminology. We have a term called a data subject, and that is essentially the person to whom information relates. You know, I was thinking of where I am, hotel guests, your employees, your clients. Anyone whose personal information you process is a data subject. Personal information, if you think of anything that can identify you in a particular way or identify a person, that is personal information. Interestingly, in South Africa, personal information extends to that of a juristic person as well, which is pretty unique because other countries that have similar laws only apply it to individuals, to human beings. So that could be your ID document, loyalty program numbers. It could even be your computer's IP address. It could be the cookies that are placed on your computer when you visit sites. It's very broad. I often tell people that even a photograph of my hand, I had a car crash as a youth doing silly things. The fact that I have a crooked finger and I put it out there, that is personal information. It's biometric related. And then, of course, there's processing. And processing is very broadly defined. It's basically any activity done in respect of personal information. So even taking piles of documents and keeping them or sorting them or looking through old files of your employees and organizing them, that is processing, and that falls under Papaya, under South African law. Then we have the information regulator, who I mentioned just in the previous slide, and that is the authority that is going to be responsible for making sure that we as South Africans and those who do business in South Africa comply with our law. What's interesting is that it extends, our law governs anyone who processes information, personal information in South Africa. So if you have servers based in South Africa and you're a Namibian entity, then that personal information on those servers is subject to South African law. Then we have the responsible party, and that is the person who determines the purpose of processing. So if you are collecting information, think of it in the most simple terms. In South Africa, we typically have a security register at businesses where visitors capture their information, and that is intended, one, for security reasons and others for safety reasons, so that we know who is in a building in the event of an emergency. That information in itself is personal information, and you collecting it at the entrance to your premises are the responsible party. What you do with that is your responsibility, and you have to account for it if it is misused. I always give the example of security companies who collect that information and might go and throw it in the dustbin 6 months after the book is full. That could have major consequences. Then we have the term operator, and the operator is a third party to whom you would give that information. The example I give, and I spoke of Nedbank a little earlier, they basically handed some information to a third party marketer, and that marketer had a breach which resulted in some of Nedbank's information being misused or exposed. And in that instance, as much as it was the operator's fault, ultimately, you as the responsible party have to take the fall, and it is you that the regulator is going to come after. So very quickly, because we don't have enough time, and we would typically spend an entire morning giving you a more in-depth overview of or session on Papaya, I'm just very quickly going to highlight the 8 conditions that Papaya has and which govern how we process personal information. The first one, and it is put at the beginning because I think it's probably the most important, is accountability. What our law says is that you, as a responsible party, must comply with all Papaya's conditions. So there's going to be no excuse for you. You will be accountable as a responsible party, which means making sure that the other 7 conditions are implemented within your organization, and that your people who work with you and your outsourced service providers, so anybody to whom you might give personal information, is aware of what these 8 conditions are. And then there's the purpose limitation, which basically says you must only process what is relevant. We used to have, during our real life training, we would get delegates to fill in a form, ask them if they wanted us to market, and then we would ask them their shoe size as well. And believe it or not, 70 to 80% of people would give us their shoe size on this form, this delegate form. And the reason we did that was to demonstrate to people that there's no need to collect information which is irrelevant. So think of that in the way that you collect your information as well. I'll give you an example shortly on how that went wrong for Google in the European Union. And then there's purpose specification, which is if you're going to collect it, it must be used for that specific purpose only. Further processing, so once you've collected that information and you've used it for that specific purpose, are you permitted to use it for something else? Well, the long and the short of it is that it must be compatible with the original purpose. The example I give is when I arrived back from the UK way back, I subscribed for a cell phone with MTN. Lo and behold, 2 or 3 months later, I was getting calls from estate agents trying to sell me property in some estate somewhere. When I asked where that information came from, they said, well, it was a database that MTN had sold at that particular point in time. I subscribed for a phone. Now suddenly I'm being sold as real estate. That, if it was happening now, would result in serious problems for MTN. And then, of course, information quality. You must keep your records up to date and keep them accurate. Not only because it's good for your business, but it could also be extremely important for those whose personal information you are processing. Think of this. You might have a staff member who started 10 years ago and was with a particular partner and has since moved on. In the course of an emergency, you might need to contact next of kin, and you're calling the ex-partner, which is not going to be produce the best results if it was a bit of an acrimonious split. And in the emergency, your information is outdated and might cause further problems. Then we have a principle called openness, which is basically that people should have access to their records and see what you're doing with their information. In certain instances, you might be processing information that is outdated. And the typical example I always give is of credit agencies or credit bureaus, which sometimes would process information relating to judgments against you, for example, perhaps as a company or as an individual. And you might have applied for and been successful in rescinding, in overturning that judgment against you because it affects your credit record. But 6 months or a year down the line, it still reflects that judgment. So in that instance, you should be able to ask what they have and have the opportunity to correct it. The next one is security safeguards. And basically, this goes to a bit of what Michael spoke about, having appropriate security in place, because it's not if, it's when that breach happens. You need to be able to show that you took reasonable and appropriate organizational measures for your type of entity. And then lastly, data subject participation is essentially very similar to information quality, but in this instance, again, it allows people to update their records and allows them to correct their records. So just as far as practical examples are concerned, how do you like my animation? Us lawyers get pretty impressed when we're able to at least do the most basic things with PowerPoint. So as far as accountability is concerned, one of the first and most important things you can do to comply with POPIA, if it applies to your organization, even though you might be in Namibia. And remember, this doesn't apply to POPIA only, because when you see further on, it will help you when it comes to GDPR as well, if GDPR applies to your entity. But basically, as far as the typical problems that occur, you'll see that 47% of C-suite executives who were interviewed in this particular survey, and you can go and look at the survey yourself. It was the Shredded Data Protection Report in 2019. they say that their next breach is likely to occur because of human error. And the simplest thing you can do, and the reason I'm suggesting this is because it sort of strays into Michael's area of risk management, is if something goes wrong and you're able to demonstrate to the information regulator, firstly, or anybody who sues you after that, that you took these steps and you trained your staff, in that instance, your liability and perhaps the penalty is likely to be far less. So take that into account. The next one is purpose specification. And again, as I mentioned, when you collect information, think of what you're collecting it for and only use it for that particular purpose. So there was a major case that went to the European Court of Justice. And essentially what it dealt with was that there was an electrical utility that started suffering major losses because of fraud. And what it started doing was it started using artificial intelligence to monitor its smart meter usage, because that AI was then able to determine who the most likely person was to be tampering with these smart meters and to be engaging in fraud. And of course, when they caught out some people, they took issue with the fact that they were being monitored and their usage was being monitored, which entailed the use of their personal information. But in this instance, what was held was that if you're giving your information over and if you're undertaking to use the smart meter properly, then at the same time, it should be allowed that your usage is monitored to avoid fraud. Think of another instance of the use of personal information, which we had to advise on recently. You might have an internal audit department. Now, what some internal audit departments are starting to do is that they are taking information that they hold, so information that you might have given when you signed up, like your ID number or any other basic information that an employee gives when they sign up with an employer. And we're then using that in conjunction with third-party information, be it reports from credit bureaus, social media posts that employees put out there. And they were using that and then using very special software to create a profile to determine whether somebody was living beyond their means and, in fact, whether they might have been engaging in fraud within the organization. And of course, under South African law, under POPIA, when it comes to profiling, in other words, creating this profile using different information sources, that is also regulated under POPIA. And the question then is, are we, as this particular organization that are doing this fraud control and investigations, can we use the information that we collected just for the employee when they registered in conjunction with this other information? And are we allowed to do that? And basically, our conclusion on that aspect was, and you'll have to pay for an opinion from me. No, I'm kidding. Was that you can in specified circumstances and subject to what the Act says. So purpose specification, be very careful because that can also get you into a bit of trouble. And that happened, in fact, it was Google. As I mentioned, what was happening was that they were collecting information, and more recently, it also relates to Amazon, collecting information for purposes of sales of goods. And then what was happening was that information and the purchases that were being made was used to create a profile to then have targeted advertising put towards the consumers. But in that instance, what was held was that, or the argument by the regulators, is that when people buy, they are buying. And even if you have terms hidden somewhere that says we are going to use this information also to create a profile for you, in that instance, it is not sufficient that you have those very hidden terms. If people are buying, that is all that you may use that information for. And you've got to be even more specific if you're going to use it for other purposes. So I think there was some research that was done that it would take you a couple of hours to read Facebook's terms. That's not going to help if you have certain terms and conditions hidden in very comprehensive terms like Facebook's. The next one, keeping records for an appropriate period or for as long as the law allows it, that is extremely important. In South Africa, for example, the South African Revenue Service will require you to keep information for 5 or 7 years. I can't remember exactly. Other pieces of legislation allow you to keep laws for information about your staff, for example, for 3 years or 2 years after they've left. In this particular instance, Cathay Pacific had a loyalty program, and what they did was they undertook to only keep this certain information for a certain period of time after people stopped using this loyalty card. 7 years after, basically what happened was Cathay Pacific then had a breach, and it was found by the investigators and the information commissioner that they had kept certain information for up to 7 years after they were supposed to have gotten rid of it. That was exacerbated by the fact that they had poor security systems in place. So they were slammed with a punitive fine because their customers had always been under the impression that their information would have been deleted after a certain period of time. That wasn't done, and therefore the information regulator threw the book at them. So keep information for only as long as it's necessary or as long as the law requires, because if you keep it for longer, one, it creates risks and problems for the data subjects, being your clients, and two, why keep information when it's going to cost you, whether it be storage space or server space, to keep it as well, and just increases your risk. The next one relates to security safeguards, and Michael touched on some case studies. But for us, one of the most recent ones was Transnet, where they suffered a ransomware attack. And as I said, they declared force majeure because in their standard terms and conditions, they had a force majeure clause. So for those of you who are not lawyers, force majeure is basically a sort of get out of jail card, which allows somebody who is a party to a contract a bit of time to fix an issue that could not reasonably have been expected. And Transnet basically in its terms and conditions said that this was an issue that they could not reasonably foresee. And I went and looked at their terms and conditions, first of all, and then I did a bit of research on that particular type of ransomware. And my view, and some people might differ, is that if you haven't done what was expected of you, this was a known risk that you were able to foresee, whether it be by way of training or whether it be by way of best practice. And a couple of government agencies across the globe have identified this type of ransomware and have made recommendations as to how it could have been countered. So in Transnet's case, my view is that they could have done more to prevent that ransomware attack from happening, or at least mitigate it by instantly being able to move to a redundant center. But it took them a week to recover from this. So the issue for them there is if they are subject to litigation, whether it be by the information regulator in South Africa, or whether it be by unhappy clients who were unable to dock in the port, I think they're in a bit of a pickle there, and that defense of force majeure is not going to work. The other example I give is of Experian. It was in 2019, if I'm not mistaken, that they literally handed over a flash drive that had a few million clients' personal information on that. And essentially, somebody just pitched up and said, I'm one of your clients. I'd like this database. Please give it to me. And one of their staff members handed that over. In my view, simple training and proper processes, much like what Michael can offer, I think, would have resolved that problem. And if you think about it, I think it was a few million. It might have been 27 million data records that were handed over. Even if there is a fine of just 10 Rand per data subject or per record, that is a lot of money for Experian to pay. So these simple processes, procedures, and if you can just put them in place, even though POPIA doesn't apply to you, will certainly go a long way as far as a breach is concerned to mitigating your risk and your losses. Now, just a quick tip. I'm not sure how much time I have left, David. If I don't have my watch with me because I'm on holiday.
You're good to go, so you've got another 5 minutes.
Okay, brilliant. That's all I need. So it's just to give you some examples of breaches. We've seen the typical criminal hacking ones, exactly what happened to Transnet. And here I'm trying to stray into areas that I don't know much about. I'm going to use fancy terms like these attacks occur using malware and SQL injections and fraud and social engineering and phishing scams, and I haven't mentioned ransomware there. But that's typical criminal hacking. So you will still be subject to investigation and potential penalties if the information regulator finds if you're the victim of a criminal hacking attack. Likewise, human error, which can occur without any malicious intent. And this goes to Experian, for example, where if I'm correct, it's alleged that they basically handed over a flash drive with these 27 million records. There might not have been malicious intent by the staff member in what they did, but that's still going to result in a fine, potentially with penalties, simply because they didn't train the staff member sufficiently not to do something like that. We've seen in the UK, there was a major case that occurred where somebody who worked for an NGO, instead of blind copying a file an update on HIV treatment, in fact, sent it to the entire CC list. So essentially, everyone on that list who was receiving that treatment could see everyone else exposing sensitive health information. And again, in that instance, there was a punitive fine by the Information Commissioner. There's also, of course, unauthorized use, where employees might access elements of the system, of your system, that they're not entitled to. The one that comes to mind is the South African Revenue Service sanctioned an employee who went and checked the status, tax status of an ex-partner, personal partner, simply because they were spying on them. And that in itself is unauthorized use. And of course, there's physical theft where laptops and smartphones and other devices are stolen. But what do you do when something like that happens? Well, of course, you want to make sure that firstly, your organization's information is protected, and you would hope that at that point, any device that is stolen is encrypted. The big issue or the big example case study was that of Zurich Insurance, who strangely enough, their South African branch was processing information of UK customers here in South Africa, and the servers were backed up off-site by taking a physical drive to the storage site. It so happened that along the way, this physical drive fell out of the back of the archiving company's truck and was found, and people could access the information of 47,000 British clients. So there wasn't any fine imposed here, but at that particular time, the Information Commissioner in the UK imposed a fine. This is a while ago, a fine of £250,000, which at that point in time was one of the highest fines imposed. The lesson there is, had that drive simply been encrypted and properly encrypted, the fine would probably have been zero or negligible. Now, the other mistake that is made when a breach happens is not having an appropriate information security incident response plan in place. And everybody runs around, and I'm sorry to use the term, like headless chickens, not knowing what to do and not knowing who to speak to or to get authorization from. That might exacerbate the situation. Have an appropriate plan in place. Typically, having PR people, having a director at the highest level who can make decisions about what to say, have your lawyers involved, and I'll explain why. The PR people, as I said, will be able to spin the story, because if you're a high-profile organization, you're going to need to pitch the story in a positive way, if there's such a thing. And of course, have your IT people on board, because you're going to need to investigate with speed. But what happened in a particular instance, we were advising a listed company that had a major breach. And theirs was pretty serious, because they basically processed the information of many of the other listed companies on the Johannesburg Stock Exchange. And in this instance, a disgruntled employee basically went in and deleted their entire system, including all their clients' information. What then happened was they immediately acted as they should have, flew in a forensics company to try and find the source of the breach so that they could stop it and identify the perpetrator. But they produced a report, and the report essentially said that they were negligent in that when the employee left, they had not followed the appropriate procedures to deprive the employee of his or her rights. So they were basically at fault. The problem there was that that report was commissioned by the IT department. And and I won't tell you what the outcome was and whether their clients ever found out, but in the event of litigation happening, they would have had to disclose that report. However, had they followed slightly different steps, which is basically make the lawyers who are briefed on the matter the holders of this particular instruction to the forensics company. That then essentially becomes part of the legal advice in anticipation of any litigation and need not ever be disclosed because it is privileged information. So where it is a completely negative finding and actually implicates the organization, then at least you don't have to hand that over, whether it be to the information regulator or whether to people who are suing you as part of the discovery process. So remember that. Try and keep that sort of information legally privileged. Make sure you have a team in place. At least once a year, go through some sort of mock exercise. Can you, as Namibians, process EU citizens' data? Well, I'm running out of time, so I'm going to quickly go through this slide. Basically, the GDPR caused a lot of controversy when it came out because it basically extended its jurisdiction into almost every other jurisdiction and country in the world. And very much like Papaya, it regulates the processing of personal information, but of course is focused only on natural persons. There are many similarities between Papaya and GDPR, so I'm not going to go into too much detail on this slide. But does it apply to you as Namibian entities? And essentially, if you'll see on top in the UK, I think that's where the UK is, there's an entity there, and there's a South African company or a Namibian company at the bottom processing on behalf of the UK company. Well, because the UK, and of course I've had some very wise and alert people say that the UK is not part of the EU anymore. There's still some arrangements in place, so this will still apply. But basically, if you're processing it on behalf of a European or a UK company, you are subject to GDPR. Likewise, if somebody in the EU subcontracts certain operations and outsources that process to you as a Namibian entity, GDPR will apply. And then thirdly, if you as a Namibian entity are specifically targeting customers and clients in the European Union, again, GDPR will apply to you. I won't go into the nuances of how this is written in the Act, but if you just keep that in mind, GDPR will apply. So very quickly, as scenarios, and I'm not going to ask for answers, if you're a Namibian company without any European Union subsidiaries offering marketing tools and services via a website hosted in Namibia to individuals in the EU, does GDPR apply to you? Yes, it does. If you're a Namibian hotel booking business using cookies to track customers, including EU customers, browsing in order to target specific hotel adverts to them, bookings.com, etc. Yep, if you're specifically targeting EU customers, it's going to apply. If you're a Namibian retailer with a website for online shopping, and the website is accessible to individuals in the EU in English, the currency, however, is Namibian dollars, and the address fields, in other words, when somebody wants to buy, they'll only be allowed to buy if they give a Namibian address. Will GDPR apply? No, because you've taken steps to try and keep European Union citizens out. A lot of scare tactics have been imposed when it comes to enforcement and penalties as far as Papaya is concerned. 10 years imprisonment or a fine not exceeding 10 million. That's what people have been using to kind of scare South African companies into compliance and appointing consultants to come and get them sorted out. But remember, these fines, and likewise with the GDPR fine, these are in instances where there's been a willful and intentional avoidance of the act or instructions from the information regulator. So you must have been really bad to have the maximum fine imposed, or gross negligence as well. As Michael mentioned, 4% of global revenue, or 20 million euros, whichever is higher. So again, in this instance, if you look at the situations where these fines are imposed, it's been really where people have abused the system or taken advantage of individuals. Very quickly, I'm sure I'm over time now, but I thought I should just give you a quick overview of the South African Cybercrimes Act. It was passed in May of this year, even though it's a 2020 Act. and it's not fully effective yet. But something that we are pushing for as people who work in the sector is for this act to be passed and made law as soon as possible, because at the moment, pursuing people, prosecuting people who engage in unlawful activity online is still a bit of a convoluted process because we rely on outdated legislation. It used to be called the Cybercrimes and Cybersecurity Bill, which dealt with two aspects, but it's been split into two. This act only deals with cybercrime, whereas cybersecurity hasn't been dealt with comprehensively anywhere, I think partly because the papaya makes provision for it and there are one or two other pieces of legislation. Its objective basically is to create offenses which have a focus on cybercrime and to criminalize behavior that involves online activities and communications. As I said, it's cybercrime focused. And what's also important is that it deals with malicious communications, threats via data messages, or the disclosure of intimate images. Some people refer to it as revenge porn. In those instances, it specifically deals with how you would prosecute those images, those contraventions. It also defines and provides for what would constitute an intimate image. It has a broad range, and what I think is pertinent, if you look to the picture on the right, you know, it covers attempting to, conspiring, aiding, abetting, inducing, instigating the commission of an offense. So we had some debate in July when we had some of our problems, and the question was, for example, you might have seen Dutuzile Zuma Sambudla. She tweeted something like this: Durban City, we see you, Amandla. And she tweeted pictures of attacks happening on the highways. The question was whether she would have been able to be prosecuted under this act for instigating or inciting. The general consensus was that, yes, she could have, had the act, of course, been in force. I think what I must also highlight is that if you are an electronic communication service provider or a financial institution operating in South Africa, please be aware that it has reporting obligations for you insofar as a cybercrime might have occurred on your systems. And importantly for us as South Africa, capacity, the people who can actually do this work and carry out the investigations. We have a shortage of adequately qualified people. So the Act actually imposes an obligation on the minister to liaise with higher education institutions and to develop programs that empower the South African police services to investigate this better. And on that point, I'm not going to do a nice conclusion. I hope that I've conveyed sufficient information to at least get you to leave here with a little more knowledge. But any questions, as David said, we can deal with at the end. Thank you so much for paying attention, and we'll chat later.
Thanks, Lucien. Excellent. Thank you very much. That was really informative. Everybody, I hope you're all well and intrigued. We're now moving into a more practical session where we wanted to look at cyber risk itself, get an idea of dealing with cyber risk, and then looking at different ways of dealing with it. One of those being the digitization of the cyber risk process. So just a quick question. I can't see everybody here. Just is Graham here? He's also away and he was been battling to connect. I just want to check if Graham is here. Just give him a minute here just to see if he's online. Otherwise, Warren, if I can ask you, please, if you could just make yourself available. Warren Glencar is a partner at BDO Namibia and also runs the IT division. Warren, I think you'll introduce yourself, and just to set the scene about how we're going to proceed from here on is through a real case study which Warren's agreed to share with us. So Warren, over to you.
Hi, David. Can you hear me?
We can hear you, Warren, and we can see if you just want to share your screen.
Good, wonderful.
Okay, Warren, you're good to go.
Good morning. First of all, thanks, David, for inviting us to share our journey. Well, I think what is particularly good to us is that we know that with BDO working with Checkmark, that we can and all your experts like Michael and Lucien and Graham and yourself, we certainly feel a little bit rest assured to dealing with some of these issues that have been, I sort of kind of feel forced. If I talk as a BDO partner, then I feel like I'm forced into some of these things, as opposed to just complying whenever I have the time to. So David asked me to just sort of give you a blow by blow of what has happened with BDO over the last couple of months. We've asked Checkmark to assist us with the process. So hopefully it will give you guys. Well, I'm hoping at the end of the day that you're going to recognize that most probably one or two of your organizations are also in the same kind of situation we are. We're being bombarded by GDPR, POPIA. We've got business in South Africa, in Botswana, with Europe, and you really sort of don't know where you are, and you're feeling quite overwhelmed. So just to start the slideshow, I'm going to do a little introduction, and then why did we start with our CRM assessment, and then our journey so far, and then we'll have a look at some questions, although David has said that we can rather leave those till the end. So my name is Warren Carr. I've been an IT partner at BDO Namibia for the last 20 years. We've got 4 offices throughout the country. I've been, as I said, 20 years in the auditing and accounting profession, although I am not I'm not a CA. I'm more sort of on IT systems, so I'm a Sage Pascal certified installer and trainer, accounting and payroll, and I'm also a Xero certified advisor and migration advisor. So so you can understand that not being a lawyer and not being a cyber expert sort of puts me into a field where when you're confronted with POPIA and you're confronted with GDPR, that you sort of kind of feel overwhelmed. So why did we decide to do the CRM process? So first of all, when we started the process, we realized that a lot of our IT policies were actually outdated. And we're dealing with very sort of mundane things and not really adapting to what's going on in the market. Especially because of our growth over the last couple of years, our IT systems had not kept up, and our reporting and analysis of IT-related risks was also lacking. So what we were finding is we were getting further and further and further behind, and basically felt like we were driving. As information technology-related business risks continued to increase and evolve, our firm needed to find a resilient way to address these risks. So, we climbed on board with Checkmark, and we decided that, it would most probably be to our advantage to rather get a team of experts in to assist us with this process, because in particular, especially if you listened to what Lucien had to say, GDPR, the nuances around GDPR and POPIA, you don't think that you need to comply with them, but if you really sort of go and look at your business and look at what's going on and who are your clients, then you realize, actually you do need to comply with these acts, and there is a risk for you, especially in particular BDO. BDO is a global organization, so if you're looking at 4% of global revenues, you can understand why the next point on my slideshow was BDO Global Risk Compliance. So BDO has developed a BDO Global Privacy Policy that basically deals with GDPR compliance, POPIA compliance, and a lot of the acts around the world. I think there's one that's also coming out in sort of the Eastern part of the world. So they've developed a BDO risk compliance to deal with all of these, because a client that is a UK client will most probably have a branch in Namibia, or could have a branch in Namibia, and hence, you know, we would need to be GDPR compliant. So we risk, if we are not compliant, in actual fact losing referrals to our firm because of the risks related to implicating BDO globally, because we are not GDPR compliant. So that was my next point: GDPR and POPIA developments both globally and regionally, lack of local expertise and relevance in Namibia. I think Lucien also dealt with that. You know, we don't have any acts. So just to throw up your hands and say, previously I used to do that when our global compliance people used to come and say, well, we don't have any local acts. They would specifically ask us, are there any local acts that deal with, you know, private information? And we just say, no, there isn't. That's not good enough anymore. And that makes us very worried. And we realized that there was way too much work to do. So all of the above factors, if you look at the fact that we were growing exponentially, our IT infrastructure and our IT policies were sort of lagging behind. What it led to was a lack of focus, and we were more focusing on sort of disaster management. You know, networks down, bring it back up. You know, need a procedure for something, do a procedure. Not really looking at what kind of information we're keeping. More of trying to please our clients, the IT department's clients, obviously our staff, and furthermore to that, our clients at BDO. So this lack of focus on real risks was inherent throughout the firm. I think it was from bottom up and from top down. So you really had sort of, you know, our partners in the firm that weren't really concentrating on it, and we had our IT staff that were also just washing over it. And we needed to urgently do something about it. So we knocked on David's door and Graham's door and Checkmark's door in particular, and we decided that we would actually do a CRM assessment. And to do that, we went and we started this journey on the MSI Risk Cloud platform in late June of 2021. I must say to you that the platform was easy to use. It was easily understandable. You an expert, no cybersecurity or expert, and I was able to quite easily follow the structures. And I'll give you a quick example. I hope that my screen is going to migrate to that. I don't think so, but let's just quickly check. If we go there. So this was our, if you just quickly had a look at it, this was the interface. I'm not really going to go through the MSI Risk platform with you, but it was a very logical, easy, thoughtful process to go through. And it certainly made us feel a lot more comfortable with how we were in actual fact approaching these things. Just trying to get my slideshow back here for you guys. So it was necessary. It was a necessary step that we needed to do. We couldn't, as we couldn't continue like we were, for fear that we would in actual fact put our global accreditation at risk. And I think a lot of companies are like that too. In particular, the last 2020 and 2021. You know, we've been concentrating on keeping our businesses going as opposed to POPIA and GDPR. And I think it was important for us to sit back and sort of refocus our efforts. Okay, as I said, we had a session with, I think it was Graham and it was Michael and I think David was involved. And it was incredibly fruitful. We've started off by defining our assets, our physical assets, and then looking at the loss of impact on those assets not being there or not being available to the business anymore. We then also looked at our threat environment, and then we are currently busy with our control assessments. So they are measured by their quality and maturity, and with those you need to actually look at remediations. So that is what we're currently busy on. And I think, if anything, what the NSI platform has been able to do is we might still be far behind, and we most probably are still far behind, and we're not where we need to be. But we're certainly on a path to getting us where we need to be. And I think that that's important, because normal business takes precedence, and I think that relates, if anyone is in the auditing industry or in the client services related industry, you'll understand that clients come first, and we'll deal with all the rest a little bit later. So I think for me, what it did is it sort of refocused my entire IT department. It refocused myself, and it sort of gave us a mission. A part of the remediations is actually setting goals for them. So, and I think that that's one of the important processes, is to say to yourself, well, I'm going to put this particular control in place, but I'm going to have it in place by a particular time. So overall, the process has been easy to understand. I think that was one of the things that, not everyone is a cyber risk specialist. And I think the NSI risk program sort of made it quite easy. So you answer the questions step by step. It was structured and focused. I think that was also very important, because you tend to lose focus. I mean, I don't know if anyone is ever, I'm pretty sure that Lucien and Michael and Graham and all of them have read through the POPIA Act, but it is a disaster to read through, and it is, you feel overwhelmed reading something like that, especially not being a lawyer. Reading these acts and seeing how they, when they need to be implemented and how that affects your business, you certainly feel overwhelmed. And I think it's important then to have a structure in place, and I think it's important for that structure to focus your attention on the right areas. I think another thing that was very important to us was the reporting. A lot of our BDO Global compliance relies on us reporting to Global. So our accreditation has changed over the last couple of years from being sort of a form that you fill in and then they send someone around to the business to tick off whether you've done it or not, to a process that is online, and it's sort of more real time. So they assess us continuously, and I think that the NSI risk cloud platform sort of allows that also. So you don't need to deal with everything. You can, as I think Graham advised us, let's deal with the top 20. Let's take the top 20 first, and let's deal with them properly. And then once we've dealt with them and we're satisfied and we've dealt with that risk, we'll deal with the next 20. So and the platform allows you to do that. The platform allows you to come back, make changes in a structured manner. But for me, what was important was to be able to report this not only to our exco here in Namibia, but also to say to BDO Global, well, you know what, we are, my philosophy was show me a firm that is compliant, if British Airways can be taken down and Nedbank and they, people are missing things, and so no one's perfect, and I think that's also important to remember. So, but it was important for us to be able to say to them, this is where we are, this is what we're doing, advise us on whether we're on the right path. It was, from a local perspective, it was very important for our risk partner to know exactly that we were on the right path. It didn't need everything to be done immediately, but that we were on the right path. And I think another important point there was the centralized work area. So it was important for us, I've got an IT risk person, I've got an IT infrastructure person, I've got an IT, sort of compliance and IT, and it was they were all sort of working in their own different areas, and no one, because everyone had a separate part, no one really had a full picture of what was going on. And so the centralized way also gave us better structure and more focus with regards to what our real issues were. And then obviously the last point that I must say, is that the guidance from Checkmark and all of their experts and their industry expertise was invaluable to us. I think part of us, being able to climb this mountain or start climbing this mountain was through the help of them. So we're very grateful for that, and we're looking forward to. This is a journey. This is not a. I think David does mention this quite often, and this is not a sort of, I'll come in, do the assessment and then we leave. It's a journey, and I think that's the most important part. And is that you're not going to get everything done in one session. You're not going to be able to apply the inside risk program and in 1 month you're going to get a tick and say, okay, you're compliant. That's not going to happen. This is a journey. This is an ongoing thing. We're going to have to continually, as technologies develop, we're going to have to continually change most probably our risk profiles, our risk appetite, and then also have a look at, how we need to change our controls to adapt to a particular, a new threat that's come on the market. So this is a journey. It's certainly not just a project. That we're very grateful that Checkmark is on board with us for. So I think I will leave it at that and transfer you back to David.
Thanks, Warren. Thank you for your insight. We thought it was important to give a case study in cyber risk management, because, as you'll all be aware, nobody is ever cyber secure. At best, what we can be is cyber ready, and cyber ready begins with a risk assessment, in understanding your business and being able to work in a structured way in order to evaluate, understand, and be able to manage your risk. So what we chose to do for this next section, once Warren just stops sharing over here, Warren, if you can just stop sharing, then what we're going to do is we're just going to take you through cyber risk management and why there's a huge transformation happening as businesses move into the digital world. And then Michael's going to come back again and give us a live demonstration in the system just of some of the more key areas that help you to focus on the key issues in your business, help you to build out what's necessary, and then to deliver a organized and structured risk management program. So if I can just share my screen here with you now. Okay, so what we're talking about now is cyber and information security risk assessments. And as we said, in any cyber journey, this is the best place to start. Some people want to jump in with training. Some people may even be doing vulnerability assessments and penetration tests. But most companies, certainly in the SME environment, have not put together a comprehensive risk management process and don't understand the risks that face their business. And what we deal with in the cyber environment when things go wrong is we deal with what companies call a black swan event, an event that's more catastrophic than they may have thought about, or they may have thought may have had an impact on their business. But in actual fact, many black swan events are actually events that can be managed or managed in the main to a greater or lesser degree. And that all depends upon your control environment and how much time you spend in addressing the risks and looking at them from different perspectives to see what impact they may make in your business. So effectively, I'm quickly just going to go through 5 slides because I'd really like you rather to see how the digitization of this risk management process far outweighs the traditional audit. It's actually a disruptive technology where we're now saying, and the cyber community are saying, that if AIG and Aon are putting cyber risk as the most important risk on their global surveys, then to go and look at your risk assessments once a year when you do your audit or twice a year is no longer good enough. And one has to start moving into a continuous monitoring and reporting environment. What's also very, very important is to bridge the gap between the board and the IT and the rest of the business. IT in particular, because IT often talks in a language that the board doesn't understand. But what they both need to understand clearly is that if they don't get this communication right, companies are effectively going to fall foul of their readiness and probably the law, and could be the victim of a cyber attack or penalties coming forward. So we want to just quickly look at cyber and information security risk assessments, what they are, cyber risk assessments methodology, how it's disrupting audit, not in the sense that audit's a bad thing, but that one needs more than the traditional audit. How do you build up cyber resilience? And then going back to Michael to have a live look at the system and just look at some of the things that are happening. So the first question that we ask ourselves is, can the organization provide assurance that that cyber risk has been addressed adequately? And it's a very, very difficult question to answer, because what does adequately mean if you don't know that what you don't know, and tomorrow you may be a victim? So if you are unable to identify, assess, and manage the major cyber risks facing any organization's business model, then most certainly an unexpected result will cause significant loss of stakeholder value. So the beginning of any process, as Warren spoke about, is to identify and assess the assets, to then understand what the threat environment is, and to link those through AI and an automated process, and then to begin a process of defining the control environment, which is important, which is incredibly important in how you see and how your company views its risk appetite. And often we lose sight of that. So we come in sometimes as consultants, and we want to try and build a castle where the business really needs something a lot more simple. And what you need to do is get an assess where the business risk appetite sits, because one has to have the flexibility in the assessments to tailor make them towards that risk appetite, so that you're not putting in preventative measures which are not necessary or cause business disruption, or also will fall outside of the business budget. So being able to digitize this process and be able to change it gives one the ability to certainly set up a bespoke development assessment for the business itself. Because without the effective application of suitably designed and configured and implemented risk management tools, techniques and methodologies, effective cyber risk management cannot be implemented. And I'd like to just pause here and give you just a comparison between 2 cases that have happened in the past. And one could compare them all, but the NHS, which was also hit by the Petia virus, the non-Petia virus that Lucien spoke about, is a classic example of effective cyber risk management versus British Airways, or maybe let's look at Target. Target being the large retail firm in the United States. Target have spent money on cyber security, and certainly because of the size of their company, these mammoth American companies are forced to comply with legislation and obviously risk and compliance. But what happened with Target is that they were subject in 2018 to a cyber breach, which resulted in the loss of 30 million of their customers' personal information and credit card details. Now, we heard this from Shah Simkins, who is the head of global insurance for cyber for Aon. And what happened there was that they had insured themselves for a loss of $100 million, which was paid out immediately to them, or as soon as it was possibly shown that they had suffered this loss. But to date, Target have lost $250 million. Well, it's been estimated that the losses resulted or were upwards of 250 million. Because in their assessment, when they looked at their cyber risk insurance, what they didn't do is look at the consequences of a run of bad publicity on their company, having lost this critical data of their clients. And what clients were simply doing was moving from Target to a whole plethora of other American service providers that started promising them far greater security and customer service. Now, what's interesting about that is they had foreseen in their risk assessments that they could be a victim of cyber, but they hadn't really planned it. They hadn't done scenario planning of what would happen and how they would best handle the cyber loss. So while they had insurance, they were able to treat the risk or transfer the risk. They were able to transfer the risk to insurance. They certainly hadn't evaluated it correctly, and they hadn't looked at the kind of black swans that happen once the incident is already occurring. So their management and control environment and the way they responded to the cyber risk was totally out of sync with what they really needed. If we juxtapose that loss that Target suffered and continues to suffer with the national healthcare system, that was also hit with a not petty cyber attack, then what you had there was a CIO who was meticulous in his management of cyber risk. Now, what happened in that is that the national healthcare system went down, and for a weekend, none of the British hospitals were able to admit customers into their environment. Or that admission process was done manually, which left a lot of patients at high risk, and there was loss of life as well, which was related to this process. So very soon thereafter, Parliament called for an inquiry, as one would expect they would do, and they called, the first person was the CIO. And he arrived at the hearings with two files under his arms, and came in quite calmly. And effectively, they asked how something that really was a patching issue hadn't been done, and why the NHS had been left so vulnerable, where risk assessment and risk management is so much ingrained inside their business process. And he was very, very quick to shut down the people taking part in the inquiry with the two files that he had. And what he had done is he had printed out his request to the board for a organized and implemented structure to deal with cyber risk. He had lists of emails that he had sent to the entire organization, asking and making requests for certain processes to be put in place, for certain budgets to be allocated. And in the second file, he had all the responding emails, which either had gone to lack of budget, lack of interest, or focusing on the business rather than in the risk environment. He walked out with his job, while most others don't, because he realized that cyber risk management and cyber itself is not an IT issue. It's a business issue. And when we talk about cyber risk, and when we go through the processes of looking at the procedures and the assets and the threats facing the business. The input from the different segments of the business is absolutely incredibly important, that it be brought to bear in a document that's easily legible, easily manageable, and can be followed in a organized fashion. The next thing is, can an organization provide assurance that the cyber risk has been addressed adequately? Because it's become imperative that all boards and leadership teams of businesses and organizations have a thorough, up-to-date understanding of their threat landscape and associated controls to ensure the implementation of cyber resilience within their operations. This goes down to the fact that if you fall foul of law, can it reasonably be shown that you acted in accordance with best practice to secure your business, to secure the data, and to secure the process with which it is incumbent upon you to do? British Airways is a very, very good example of this, because in British Airways, as Lucien was talking about earlier, they're part of the aviation industry, and nobody would ever point a finger that they, one, don't comply with very strict legislation, two, don't spend money on cyber readiness, resilience, and prevention. And in fact, they've got one of the largest NOx and SOx in the European Union. But when they were hacked, it was through their website. And they there lost, I think it was 300,000 or 350,000 members, personal credit card details, and personal information over a 6-week period. When the regulator looked at them, although they had spent all of this money, when they looked at this area of risk, the website and the transactions that pass between a client, a customer, and the company, there was not enough security in place. So they hadn't stopped to look at the website as a risk and put in a control environment commensurate with the high level of expectation that everyone has for actors in the airline industry. And that led to the fine of 1.5% instead of 4% of £180 million. That could have easily been as close to £500 million had they not been British Airways. So with a platform, with an interactive platform, with a live platform, one's able to evaluate risks, evaluate the threat environment, take note of changing threats, and be able to feed that information on a continual basis through the organization to the board of directors, who then have to take responsibility for the actions they allow to happen or don't allow to happen in the board. But if you're always going back to Excel spreadsheets, if you're always going back to risk registers that no one sees because they only get pulled out once or twice a year when the auditors come in, you're going to be in problems. Inside risk, Michael will go through, but effectively, as I've mentioned before, what you need to do to begin this process is understand your assets. You have to understand the threat environment, and that threat environment is how certain external threats will affect your business and internal threats will affect your business. But to be able to absorb those and to measure them by your own risk appetite, assess the control environment, to map it to your risk environment, and then create a roadmap to remediation. And often what we don't do, if we try jump in to cyber or information security management without doing the proper assessment at the beginning, is our roadmap to remediation starts with the remediation of things that are not going to be catastrophic if they brought to bear or they happen inside a business. So you have to be able to prioritize them, and it's only through going through this process that you're able to prioritize where your remediation is best spent. That can then be built in over a period of time, over a period of budget cycles. It can be built in according to urgency, and everybody can understand why those are the key things that need to be addressed. So the businesses, when we talk about cyber resilience, we're talking about businesses. They must be adequately prepared for mitigation of cyber attack. The most valuable digital and physical assets are adequately secured. Have you stopped to think about those things? with all staff within an organization and the business are educated and informed and trained to prevent attacks? Have you thought about that and who the people are that sit and manage the major risks in the business, or maybe the data? And the appropriate and adequate cyber insurance cover is in place and affordable. So I'll leave you this before Michael just quickly goes through the system, is that I always use it as an example, is the attacks on 9/11 on the Twin Towers. If we were looking at this now as a group of 80 people, and I said to you, which one of you people on this the webinar today would think that on 9/11, Boeing 747 would fly in at 9:54, would fly into the South Tower, ultimately bringing it to the ground? How many of you would say that's a possibility? 99.999% of the world would say it could never happen. But it was written about, it was documented in intelligence agencies and law enforcement that there could be an aeroplane attack on a building. If I said to you that an hour later, another plane is going to drive into the North Towers and also bring that tower to the ground, how many of those who thought a first attack was possible could have said a second attack would happen in an hour? So of that 0.001, maybe 0.00001 would actually have said that it was possible, but it had also been written on. It had also been written about. There were two interesting real black swan events that came through this, which is quite interesting to understand, is that there was a data set in the South Tower, and there were 8 businesses in the North Tower that backed up all their data to the South Tower data center. When the 2 buildings came down, those 8 companies were obliterated from the memory of the world. They had looked at their risk in a different way, and obviously this was a black swan event that most people, or no one, could have foreseen happening. But the way that they had backed it up, the things that they had done, possibly may have been able to have been done better, because we actually have looked at scenarios like that and looked at how backup the DR process works, etc., and seen that there are some ways of obviously establishing security in a company with a different approach. Having said that, the insurers of the Twin Towers had only insured one of the buildings. They had thought that one building might collapse, but never that there would be 2. So from an insurance loss, there was a great loss that was suffered by the owners of the building. Having said that, I bring the example only as an example that when one's dealing with risk, one has to look at it with open eyes. One needs to get professionals who can help and look and see what is happening in the environment, and also to see how that environment is relevant for the businesses that we're talking to and the businesses in front of you. So it's no use building processes for businesses that aren't yours. It needs bespoke development. And Michael, with that, I would like to just allow you to use the last few minutes we've got together to take the team through the process of just having a quick look at the the Inside Risk platform. Thanks, everybody. Appreciate your time.
Excellent. Thanks, David. Let me share my screen. Are you seeing the screen?
Yes, we've got you, Michael.
Excellent. I'll show myself as well. Oops. There we go. Okay, so this now is almost the practical side of the earlier slide that I showed with regard implementing a registry mechanism to have oversight, management and monitoring and reporting of cyber risk. So this is now a cyber risk module, and immediately you can see it's a digital registry that's implemented, and straight away what one wants to have is a methodology and process that is simple to follow. Thanks, Warren. Warren affirmed that the experience of clients is one of ease, and it really, I'm very at a high level going to show you how the methodology works that gives confidence of completeness and credibility. So one would start at the top and identify the information assets that are at risk. So by information assets, it's those that have a technological component or characteristic, and that are the ones that could be compromised by technical risk. So straight away here, what one can do is you can filter it. So this is a pre-populated information assets registry, and as a user, you set your information assets. You can see here at the top, I can say, I just want to see the assets that we have in our organization, and I want to see the ones, so here are all the assets that we have that are exposed to a cyber risk, and I can actually even then say I only want to see the ones that are catastrophic to the business. So you can see here they've been identified. These are the assets that are catastrophic. What has happened, the system then has the intelligence in the background that these assets are mapped to the threats that are in the environment. So here's a threat environment, and of course, by virtue of the threats, you have the vulnerabilities. So just to give you an idea, these are the high-level categories of threats. The big one is nefarious activity. If I click on nefarious activity, it drills down to the subcategories, and each one of these subcategories has descriptors of actual threats. Now, these threats have been mapped to the information assets. So when one selects an information asset, so here, for example, I can just open up to so you can just see. So when one selects an information asset, by virtue of that selection, the system identifies the threats that the organization is exposed to. And each one of these threats then that now has been identified has mapped mitigating controls. And those controls are also, so it all is inherent in the system. So you don't have to invent the stuff. The stuff is just there. All you have to do is identify the information assets that you have in your business, and the system will then identify the threats that are in play and will identify what is the optimal control matrix that will be in play. So the next step after, so only having identified information assets, the system having identified your threats and vulnerabilities, you then have the opportunity to do a controls review. And you can see these are like all the categories of controls. You can see how extensive it is. It covers all the controls that you can imagine. So here you have got business continuity and disaster recovery. So there's the backup, it's a big one. But even physical security, all the physical security controls, workforce security in cyber environments is significant. You've got access management, network, all these things here. Here is the vendor management controls, because as Lucien had spoken to, operators and service providers are a significant risk to an organization. So what happens is you actually do a self-assessment of the controls you have in place, and the system then is able to identify what your residual risks are and the threats and the remedial action. So one can actually go and then, based on your self-assessment of your controls, the system gives you your risk analysis, and also then is able to make the recommendation for the best remedial action. So here you can see here's the risk directory specifically on this organization. So I can open up the risk directory just by clicking it, and it gives me a ranking of the top 10 risks. Sorry, just loading there. So here the highest risk is nefarious activity, is still ranked as critical. If I want to see why is it critical, the nefarious activity is critical. Why is it critical? It's because I've got these assets that are catastrophic if they get compromised. And here it gives me the threat listing of all the threats that are still in play. I can actually select and ask for all the threats that are unmitigated by virtue of my control assessment. So here you can see these threats are all still fully in play, and then it goes right down. All of these threats are fully mitigated by the controls in place. But one then immediately can see here, web-based attacks is a threat right at the top of the list. I'm able to now drill down on web-based attacks. And the system, so the registry does this now. And of course, this is the evidence that you as an organization then have that you've done a robust intervention and that you're considering it. When David was speaking about disruptive, or it being a disruptive or disruptive to the audit environment, it's disruptive only to the extent that the traditional audit approach was to do a review at a point in time, whereas with the registry, it is a dynamic, ongoing intervention. So it's disruptive to the traditional method of auditing. The audit now is one where the auditor will be able to review the implementation of risk management for a period. So having a registry in place like this that is monitored and managed on a regular monthly or quarterly basis facilitates that the audit function for assurance is not at a point in time, but is for a period. And by cyber management happening across the year, the auditor at the end of the year can give assurance that the risk management process for the period is in place. And I think that just needed clarification in terms of the traditional audit that is disrupted. So just speaking here to the threat review, you can see it's identifying this threat as being high. And the system then says the reason for it being high is there are control deficiencies. And I can click on the control deficiency here, and it then identifies that there are preventative and detection controls missing. I can click on the preventative control, and the system tells me which control is missing. Endpoint security controls is missing over here under preventative controls. And if I click on detection controls, you can see the system even identifies between primary controls and secondary controls. So the first thing that you want to do is get all your primary controls in place. And there aren't that many primary controls. As Warren had pointed out, you can do the intervention in tiers. You don't have to do 300 controls in one shot. You can start with the foundational cybersecurity controls and get those in place. And by that, you would mitigate a lot of your risk. So here it identifies which controls are missing, and one has immediately the intelligence for a remedial roadmap, where when I click on the remediation, it actually identifies the controls that next need to be implemented. And so the system facilitates the development of a remedial work plan. So here you can see it's actually come up here with the endpoint security controls as needing to be applied. You can see there's no application there. What's the remediation? We want to apply it. As soon as you say we want to apply it, it then takes you and develops a remedial roadmap where it allows and facilitates for action plans to be implemented. So here I can add new actions now, and it actually, you can design a remedial roadmap based on the controls, the missing mitigating controls on the threats that are still in place. So here you develop an action, you can identify a responsible person, and you can allocate due dates. Lastly, just to show you the power of it, you can now produce the reports that give assurance to various stakeholders, whether it's the board, whether it's the regulator. And I'm going to pick up on POPI here. You can see there are multiple reports that you can pick up on, and these remediation reports, but let's pick up on POPI because Lucien had given us such a comprehensive oversight of the POPI report. And so immediately there you can see it's now viewing it by condition, and it now gives you a view as to how well you are doing in line with the conditions. And so immediately you can produce that, and you can then say, okay, we need to, there's a lot in place, but there are a lot of controls that are only partially applied. And so one can actually decide to pull a remediation report and say which controls do we need to focus on in terms of POPI compliance, which is the most important report in terms of POPI. Sorry, it's just defaulted to the standard CIS. I'm going to change that to POPI as soon as it's loaded. Sorry, when I'm running on a virtual presentation, it's a little slower. So here I can select POPI, and I can say, give me a POPI remediation report. And now what happens is it just gives me, on POPI, it will actually make a recommendation by condition of, it shows which control is in place, which control needs to still be improved on. This being the ranking of the importance of the control. So the most important control is only partially applied in terms of accountability. You can see it's training with regard to organizational policy. So that's the accountability. And you can see that one can very easily, on the different conditions, identify which controls need immediate attention. And so that, in a nutshell, is a very quick overview of the manner by which this is now a register that manages cybersecurity, and you can see how it facilitates oversight for the board, and it gives a mechanism for ongoing management, monitoring, and reporting, and remedial action and evidencing. So in all of this, I mean, I didn't show you, but there is a comprehensive registry that you can pull where everything that has been done is fully evidenced. So any inquiry, that file that was taken into that inquiry by an NHS, what you actually want in that file is you would just be printing out the registry from a system like this, and that would evidence that there's due diligence, there's diligence review processes, it's credible, it's complete, and it's implemented correctly. And that would make for good governance. So I think that was a very rudimentary overview. I hope that that has given you a good understanding.
Thanks, Mark.
To the register.
That was excellent. Thank you. Friends, we're 11 minutes over time. We apologize for that. But we would like to remain for another 10 minutes to see if there are any questions. We've kind of walked a journey through governance and risk management, and looking particularly at cyber risk management and how one can begin a journey, which we find with the clients we come into contact with is generally a journey where people are not sure where to begin. And there's a beginning, there's a middle and an end, and obviously becomes more advanced with companies that have done more in this area, are looking for different types of interventions and different types of consultancy. So you can unmute yourself. I see there are some questions. Gaggery is there. If you just want to ask your question and someone from the panel can answer.
Thank you very much, Michael. It was a very good presentation for all the presenters. My question is directed to the IT lawyer. I just want to find out whether POPIA deals with individual. Can it punish an individual, or is it more focused on corporate entities? That's question number one. Number two, I want to understand how far does POPIA go? For instance, in a situation where we have COVID now, you would find companies requiring people who have pre-existing conditions to work from home. Usually institutions demand that a letter from the doctor is submitted for that person to qualify to work from home. That's now some institutions. So you would now find I am an individual having, for example, diabetes or high blood pressure. I go to my doctor, get my doctor's letter, submit to the relevant personnel in the organization, and then they share my document on public domains such as Yahoo or Hotmail, maybe for the right reasons, but my understanding is public domains are never safe, and I would never feel comfortable with my personal information being posted on a public domain. So how would POPI address that, if it addresses it at all? Thank you.
Lucien?
Thanks, Gregory. That is quite a pertinent question, given the times that we're living in. Very briefly, your first question as to whether POPIA would apply to individuals. Indeed, it would. It talks about a responsible party as somebody who processes personal information, i.e. the person who has to look after it and determine what happens to it and how it is dealt with. So as far as that's concerned, it doesn't say whether it is a corporate entity or an individual. It's anyone who processes that personal information. It does have some minor exclusions as far as its applicability is concerned. For example, your home processing personal information at home would be excluded. I always give the example of the shopping list or the to-do list that my wife gives me and puts on the fridge. You know, that is excluded from POPIA, as much as it might include call the handy person, call the plumber, etc. That is processing, but it's excluded. But to answer your question, it applies to anyone, whether you are a natural person or whether you are a corporate entity, as long as you are processing personal information that falls within that definition. The second question that you have is whether in instances where sensitive and special personal information is dealt with, particularly, as you say, in these times of COVID, and people have to present medical records or proof of perhaps being COVID positive. In such instances, what the Act says is that there's a nice piece of music going on in the background there. I need to find out who the artist and the track is. All right, it seems to have gone. I'm just going to carry on.
Please,
Sinati, I think it's you. Thank you.
Thank you.
So in this instance, POPIA has very strict provisions regarding dealing with special personal information, which is health data, sexual preferences, political affiliations. And it says that that information must be dealt with in an even more secure manner. So the fact that you mentioned that it might be posted on Yahoo would concern me immensely, because what is the purpose of you submitting, for example, your COVID positive report? It is simply to satisfy your employer that you should indeed be working at home. There's no need for somebody in the finance department or somebody in PR or in marketing to know what your actual condition is. So that would be a major concern to me and would in fact likely result in some sort of penalty for the organization, because it's going beyond what the purpose of that health report is.
Okay, great. Thank you. Sorry, if we can, we're just going to jump around for a quick question because I see there are quite a few questions. So Nee, if you've got a question.
Yes, thank you. My name is Nee, I'm from Binary City, and I'd just like to quickly find out, I don't know exactly who to direct it to, but I saw on the invite that we now have basically all the participants, or the participants that have been shared via the calendar invite to this meeting. Basically, everyone's email is now exposed, and I wanted to understand, would this then be considered a breach? Isn't this then covered by the POPI Act not to have been allowed? I just wanted to understand, in a case whereas I mean, we all end up sending out invites. Then doesn't it mean as I send invites, it should be more private and only send it to a specific individual so that other people's emails are not exposed to people that shouldn't have those emails?
Absolutely. So that was a mistake that happened in our business, that you're 100% right to have picked that up. That would be a breach under POPI. Not more to be said, but sharing personal data like that without people's permission, had there been permission stated that it could be shared in the invite itself, or may be shared in the invite itself, which is what we recommend is done, then that would be different, because then by opting in, you would be allowing your information to be shared.
All right. Okay. I understand.
So thank you for that, and we did note that, and it was a process issue that we didn't follow.
Sorry, just in line with that, then I have another question. Then, with regards to complying to the POPI Act, what would be the remediation for something like this being an exposure then?
Lucien, do you want to talk about the process for exposure of declaring that there'd been a data breach and making that information publicly available?
Yes, certainly. As far as POPI is concerned, it doesn't distinguish at this particular point what types of breaches or compromises, as it calls them, would need to be reported. So I'm quite sure that if you are quite a stickler for compliance in any organization, the information regulator in South Africa is being overwhelmed with breach reports. But essentially, there is a process, there is a form that is filled in. It is attached to the regulations, the POPI regulations, and that form is completed. The complaining party is then gives their details, gives a summary of what the breach was about, and then submits that to a portal called Complaints at POPI at Information Regulator. I can't remember the exact email address. POPI complaints at informationregulator.co.za. And then the information regulator will follow up on that from that particular point. And I do suspect that in time, they will probably categorize breaches so that they are not completely overwhelmed. They will probably also rely on what we call codes of conduct, because certain sectors will self-administer certain types of breaches. So in this particular instance, let's say you do want to report us, NI, you would submit it to the information regulator, and it would proceed from there.
Thanks, Lucien. Any further questions? Okay, so ladies and gentlemen, thank you for your time. Yes, I see, Gary, you've got a second and third question.
Thank you. It's actually a follow-up on Pierce's explanation that the message being sent to a public domain is beyond the action of, for example, the HR. What if the person who sent the information to a public domain sends to another person who also works in the department that is supposed to deal with the case? How do we deal with that? Because this person is going to say, no, but I am within my work rights. I'm supposed to have a view of this information. But the complainant says, but why don't you just send it to your work domain instead of a public domain? So could that be a valid argument? Thank you.
Again, Gagari, that would come down to what the company's processes and procedures are about. So if we had to consider that it was all done within a closed system, if I could call it that, so you might then find that you give your COVID-19 positive certificate to somebody in HR, and you then take a sick leave as a result of that because you're required to stay at home. That then needs to be captured perhaps by the finance department to record the leave days that you've taken. It might well be then a policy of the company that the person in finance, to avoid any fraud or corruption, would also need to see that certificate, which is fair enough. If those are the processes that are required, that's good. But what you would then expect is that the company itself would need to have some sort of systems in place that compel those 2 staff members only to keep that information confidential and to store it in a confidential system. Now, to extend it, perhaps it may be that the company is still in its infancy and is now still only using Google or only using Yahoo as the means of communication. One would then expect that the company would have minimum types of training to say, well, even though it is being sent to your Yahoo email address, you may not then distribute it any further than that email address, and you may only use it for capturing information on the payroll system. But if it was published in the public domain, that just cannot, in my view, be justified unless it is in an instance where in South Africa we have something called the Disaster Management Act. And it might be that for purposes of the greater public good, Lucien, who is COVID positive, is not complying with the laws and is going about the malls intentionally infecting people. In that instance, then it might be justified, but then, a whole lot of other factors would come into play. But in an organization which simply has unilaterally gone out and put your medical certificate out there for no real reason or without any proper purpose, that would concern me immensely.
Okay, so thank you very much, guys. We are running out of time. We're going to close the webinar now. We do appreciate your time. If there's any interest in this, if you want to take this forward, obviously be in touch with BDO, with Warren, with Nicole, with myself. We can put things together. We can have a discussion. We can look at issues that might be confronting you and work together to be cyber ready. If we're cyber ready, we're in a much better place to do business, to be part of the business community, and certainly to mitigate the risk environment, which is increasing at a rapid rate. Our biggest fear is that people are not understanding how quickly and how dangerous the cyber environment is becoming. It's a toxic space, but there's plenty one can do to make yourself a whole lot safer. Take care, have a beautiful week, and we look forward to hearing from you, only with good news. Take care, and God bless.